Edward Maina na Reuben Gitau rudini hapa.
Na katika shtaka la pili, and on the second count, you Edward Maina and Reuben Gitau, you are charged with conspiracy to commit a felony contrary to section 393 of the Penal Code, particulars on the 29th day of February 2024 at Gagondia Village, Ndabibi location in Naivasha sub-county within Nakuru County, jointly with others not before court, conspired to commit a felony namely malicious damage to barbed concrete poles, fence valued at Kenya shillings 2,543,184 shillings only, the property of Eburu Hills Farm Limited. Mr. Edward, do you plead guilty or not guilty? Reuben Gitau?
Your Honor, I would like to make an application for bond or bail. And before that, Your Honor, I have to put something in perspective concerning the two accused. The two accused were apprehended on 15th March 2024. They have been in custody since that date of 15th. They have also been traveled around to Kajiado for more than 3 times, Your Honor. As the charge sheet, as the charge sheet,
I got to see by that citizen.
The two have been attempted to be charged in Kajiado. However, yesterday, your sister in Kajiado delivered a ruling that they be charged within Nakuru County. As the charge has been read, that jointly with others, not before court, those others have been charged in Nairobi. Your Honor, we can supply the rulings. Those others have been charged. A list is attached, and you ask the name of David Chegemwani, who has been charged 3 times. In Nairobi, he appears at number 22 on the list. Then on the charge in Kajiado is also listed. And therefore, Your Honor, our inferences drawn is that you can see a motive that either is to delay justice for the accused, because justice is two-way, to the accused and the complainant. But now that we are here, Your Honor, we plead with the court to give favorable bond and bail terms, owing to the fact that those 25 of them who are in Nairobi had been given bail of 50,000, which was reviewed to 20,000 on similar charges. Therefore, our plea will be that the two accused persons be admitted on bail of 20,000. We undertake to avail them anytime they are needed in court. We explain to them the purport of, or import rather, of them availing themselves. because at the end of it all, we want justice. The first accused is a senior citizen. He's also a man of stature in society. The second accused is a professional journalist. He runs he's a blogger, Your Honor. And therefore, these are credible citizens of this Republic of Kenya. Also of note, the court should consider the time they have spent in custody, being huddled between Nakuru, transcends Nairobi to Kajiado. I don't know what the state is trying to prove, but then those all that we have submitted should be put in perspective. Thank you.
Ms. Kirumba?
If I may just add one or two things.
Yes?
Your Honor, I wish to confirm that I have been in the journey with the two accused persons in Kajiado. I have also been in the tribulations with the other 25 persons who are charged in Nairobi, despite the fact that the offenses, the particulars are the same. The offenses occurred in Naivasha, or are alleged to have occurred in Naivasha. For the 25, I can confirm we secured bail from your brothers in Nairobi before court number 5, before Honorable Shikwe, for 40,000 cash bail, 50,000 before Honorable Shikwe, and another set before the cases were consolidated. Another set of the accused appeared before your brother, Honorable Onyina, in court number 1, who granted them cash bail of 40,000.
This senior, just tell me what Mr. Okum has not said.
Yes. So I'm just affirming, Your Honor, there was one accused person in the set of 85, of 25, who is 84 years and was granted a cash bail. A personal bond on account of his being a senior citizen. I would urge the same consideration be extended to accused 1, Mr. Edward Maina, who is 66 years old. Your Honor, the other small thing I wish to place on record is that the two accused fear for their safety. These journeys, in their view, and with the information they have received in the cells for the period they have been there, is that it is intended to hurt them. They are not sure if they will ever reach home once they leave the courts that are distances away from their home. So we wish to place this on record that we fear for their safety. We don't know whether even after they are granted bail, they will ever reach home. These are issues that have happened in this country. Your Honor, the last general election, one of the campaign issues was about disappearances and kidnapping of suspects. And they wish to just place it on record that should anything happen to them, the state should be held accountable. As it is, they should never have been in Kajiado, and as it is, Your Honor, ordinarily, they should also not be before your court. There are persons who are arrested by the Naivasha police. There is a court in Naivasha, a walking distance from the police station. So even when your sister rejected the charges in Kajiado, surely if these charges were not meant for malicious intentions and for the intention to oppress, Nothing could have been easier than to walk them to the nearest police, to the nearest court. Your brother's CM spot in Naivasha. So the question still remains, why are they in Nakuru? They were detained in Naivasha. They were woken up from the cells in Naivasha police station. Why are they in Nakuru? So, Your Honor, I think for the record, let the record reflect that we fear for their safety. And if the prosecution can guarantee that they will reach home, we would be more than happy. But as of now, we are not even assured that if you grant them bail, they will reach home.
So can we then remand them for their safety?
No.
What do we do? You
Grant,
just
grant them bail and because the threat is not from ordinary citizens. We are saying the threat is from the state. Grant them bail and direct that the state ensures their safety back home. It is not ordinary people who have been taking them round.
That's okay. I've had
from Naivasha to Kajiado, from Naivasha to Nakuru. It is the state.
Right. Sawa.
So we would ask that you grant them the uniform terms of bail as in Nairobi, but ask the DPP to ensure their safety, that they return home safely.
You mentioned something about, you asked a question, why are they in Nakuru and not in Naivasha?
Exactly.
So do I send the file to Naivasha or I proceed?
We would be more than happy if you ask that under Section 71 of the CPC, they should be in Naivasha.
So nitume file Naivasha na ni cancel easy proceedings sama. I'm not getting you, in other words. You know they have already taken plea. They have already taken plea here. So what do I do now?
Grant them bail, Your Honor. We will deal with the rest with the High Court. I don't know whether within the counties, I don't know whether the CM's court can transfer files. I've seen it happen in Nairobi where the CM's Milimani can transfer a case to the CM's court, Jomo Kenyatta International Airport, and the CM's court in Kibera. If within the same county it's possible, you would not need to cross to cancel your proceedings, but you would ask that the next proceedings be taken in Naivasha.
Right, I have heard him. That's okay. That's enough. That's enough.
Thank you.
Ms. Kemumba, any objection to bond?
Your Honor, I do not object to the application for bond or reasonable bail terms. However, it is my submission that Kenya shillings 20,000 and 50,000 as proposed by my learned seniors is too low given the nature of the offense and the value of the subject matter. I pray that the court, in considering the same, grant reasonable bond terms or bail term, taking into account the nature of the offense. However, if Mr. Mbogwa is also apprehensive of their safety, perhaps the court can suspend bail at the moment.
Okay.
Your Honor, as we said, the terms of bail are already, they are not from out of the blues. They are the terms given in similar cases. Same terms, the IO is in court, you can confirm, in Nairobi. But for suspending bail, that is not our prayer. We have not made such an application.
Okay, my considered view is that there's really nothing that stops us from granting the accused person's bail. And I've considered the proposals by both parties, both the defense counsel and the prosecutor. The paramount consideration for me is to give terms that will ensure or will cover the accused's attendance to court for their trial. So, whereas the nature of the offence is an issue to be considered, there is also the accused's liberty and their right to be presumed innocent until proven otherwise, which are also important considerations to be taken. So, in my view, the interests should be balanced in a fair manner, and I give the following conditions for bond and bail. For bond, 200,000 with one surety of similar amount, or a cash bail of 30,000. As the question of the accused safety has been raised, let the state guarantee that safety. And we are going to take a date for pre-trial in court number 2. Give me a date in court 2.
Pre-trial for 23rd of May in Nairobi. The initial pre-trial was on 27th of March. No documents were closed. So the pre-trial was pushed to 23rd of May.
Therefore,
we take up after 23rd of May for this one. So the particulars of the judges that you can see are the same. So I don't know, we would rather we do the pre-trial in Nairobi first, then this one follows.
give me a date towards the end of April. Yes?
29th.
29.
29th of April.
2-5. If that okay with my learned friend is our kudos.
Make sure the amended charge sheet is the one on the record.
We are not to forget. Yeah.
Criminal case number E852 of 2024, Kenneth Morezi